Welcome to this Housing Ombudsman Service podcast, and thank you very much for tuning in. I'm Anthea Chilton. I'm one of the Sector Learning and Development Leads at the Housing Ombudsman Service, and in today's episode, I'm joined by Stephen Parfitt, and Steve's an adjudicator here at the Housing Ombudsman. And actually, if you're a keen listener of our podcast, you might recognise Stephen from one of our podcasts we recorded all the way back in March last year, and that was all about a case that involved multiple leaks. But hello, and a big welcome to you, Stephen, and thank you very much for coming along today. Before we sort of get started into the main podcast, would you like to come on and introduce yourself?
Yeah, sure, absolutely. So as my name's Stephen Parfitt said, I'm an adjudicator. It's nice to come back and do a second one of these. Always good to sort of share learning from the sort of frontline casework that I do. As an adjudicator, my role is to complete the investigation and determine complaints. So I go through all of the evidence provided by the landlord and the resident to work out what the issues are and to determine whether there's been any maladministration or not, as the case may be. So it's good to get an opportunity to sort of share the learning from that.
Thank you, Stephen, and it's really nice to have you back here as well. So today, Stephen and I are going to be discussing a particularly complex case that came to us for investigation, and that was in relation to service charges. So, Stephen, to start us off, can you give us a bit of background to this case and what led the resident to raise two separate complaints with the landlord?
Yeah, sure, absolutely. So this was a complex case, or really two complex cases that was rolled into one. It was regarding service charges. So the resident lives in a flat on quite a large estate with many different properties. The landlord is the freeholder of the estate and also has a managing agent to provide the services. The resident's disabled, which will become relevant later on. And the managing agent billed the landlord for services provided, and the landlord passed those costs on to the residents, whether tenants or leaseholders, plus its own management fee. The reason for the complaint was regarding clarity around what the landlord should have been charging for the service charges and the amounts. There's also an ongoing dispute's the wrong word, ongoing complication regarding whether the figures were correct as provided by the managing agent to the landlord, and then how the landlord passed those figures on. It had been going on for a number of years, so it was really quite a convoluted situation that the resident who brought the complaint to the Ombudsman sort of found herself in the middle of. So there are two complaints about two different financial years from 2023 through to 2025, and the resident paid a fixed service charge.
Thank you, Stephen. That's really sort of set the scene there for us. So what were the main issues raised in those complaints, and how did the landlord respond to them?
So the sort of bulk of the complaints and across the two goes through the landlord's complaints procedure. There were 4 complaints total, 2 stage 1, 2 stage 2. The issues were really about lack of clear communication with the resident from the landlord. The resident raised issues with the calculation of the service charges, which we thought were incorrectly calculated. Also, that she was being charged ineligible service charges as a tenant as opposed to a leaseholder, and there are different charges that can be charged between the two different types of tenure, and an overall lack of transparency. She also complained about how it apportioned the charges, and that means how it subdivided the total charges amongst each resident, and that there was a complete lack of a breakdown of the charges. So in effect, she didn't know what she was paying for. Typically, you'd see a service charges, a breakdown schedule that would outline things such as internal cleaning, external cleaning, gardening, that type of thing. Whereas the resident in this case simply had a service charge total without it actually being itemised. And that's really where the lack of transparency came into it.
Thank you. It sounds like there were quite a few layers to those 4 complaints with the 2 stage 1 and the 2 stage 2. So it sounds like there were quite a few layers to that, and not just about the service charges themselves, but actually, you know, how they were communicated and apportioned as well. So there's a lot, I can imagine there's a lot there to have to look at for both of those financial years too. So when it came to the service charges, what kind of explanations or information did the landlord provide, and how did that impact the residents' understanding of those charges?
So the main issue was that the landlord didn't provide a breakdown of the individual service charges, either at sign up, so when the resident first signed her tenancy agreement, or at any time after that. So it sent charging letters. It sent at the beginning of each financial year a letter setting out what the rent charge and service charge and management fee would be for that upcoming financial year, but it didn't break it down any further than that. And so it was difficult for the resident to understand what was actually being charged. It did provide other financial documents, and she was able also to obtain other financial documents via the tenant association. But these were highly complicated and really not fathomable by her or by us, to be honest. They were very high level and didn't really relate directly to what she was being charged for.
Yeah, I can understand sort of getting those letters with lots of figures, but with no real kind of explanation of what those charges are for. It would be, I can imagine, very confusing and make it really hard for anyone to feel confident that they were being charged fairly. So, and this case particularly raised some broader questions about the complexity of complaints about service charges. Could you talk us through how the Ombudsman role differs from that of the courts, and how we decide what we can and what we can't investigate?
Yeah, certainly. So service charges are a very complex area in terms of actual service charges and in terms of jurisdiction around them for the Ombudsman Service. The basis of what we can determine really are the matters that don't require a legal finding. So we can consider, first and foremost, whether a service was provided that was charged for. So in the most simple of complaints, it might be the resident is paying a service charge for gardening, but actually reports that no gardening has ever taken place. Then that's the type of complaint we could look into, because that's a very simple matter of fact, was there gardening or not? Likewise, we can look at the standard of service. So the complaint might be, I pay for a gardening service, the gardener did come once, but didn't do a very good job, they didn't come back. Again, that's something as a matter of fact we can look into and determine a complaint about that. We can also look at, as we can for all complaints, the landlord's communication with the resident, whether it was responsive, whether it replied to requests for information or questions. In terms of service charges, whether it provides good, clear information about service charges and responses to queries. And we can also, again, with every complaint, consider whether the landlord followed its own policies and procedures and legal obligations in terms of what it's supposed to do against what it actually did do. Where it becomes a bit more complicated is what we can't, unfortunately, consider, because it is the preserve of the courts or the first tier tribunal for property. So this includes matters where there needs to be a legally binding decision. So ultimately, whether a service charge can be charged is a matter of contract law or legislation which requires a legal determination. Also, the reasonableness of charges, and by that what I mean is how much is actually being charged, is beyond our jurisdiction, is a matter for specialist judge or tribunal members to be able to work that out and then make a ruling on that. Matters of complex financial calculations as well are beyond our remit. If it's a very simple matter of the service charge has 10 elements to it and the total is X, and actually there's been a calculation error and the total should be Y, then we can look at that because that's quite straightforward. But if it involves sort of really interrogating financial documents, then that's beyond the jurisdiction of the Ombudsman, because it requires that specialist level of skill and knowledge that the courts and the tribunal have. And all of this really is sort of encapsulated in our scheme at paragraphs 42D. We may not deal with matters that involve the level of a service charge or service charge increases, or under 42F, where we consider it fairer, quicker, or more reasonable for the matter to be decided by a court or a tribunal. So there's elements within our scheme that sort of set out there clearly the rationale for why we can't look at certain matters. The Ombudsman's insight report on service charges is a very good resource for landlords or residents like to have a look at if you're interested in sort of looking more at our jurisdiction, which is obviously available on our website. Gives sort of good detailed breakdown explanations about our jurisdiction.
Thanks, Stephen. And what we can do is pop a link actually to that insight report at the bottom of this podcast as well. So if anyone's interested in having a look, they can. So thank you. That's because it's really useful to hear, because it's often something that we're asked, what's within our jurisdiction, what the Ombudsman can look into. So in this case, as you said, how the landlord delivered the service and communicated with the resident. But then there's also what needs to go through the courts, like that sort of the actual legality or the amount of the charges, that the stuff that we can't look into. But with that in mind, what did we find in terms of maladministration in this case, and what were the reasons behind that finding?
So to come back to this case, we sort of have to sort of really take a formulaic approach about investigating service charge complaints. There's an anecdote that comes back from years ago, which is, policeman turns up to the scene of a crime to investigate and immediately starts trying to work out who committed the crime, before then realising no crime took place at all. So the first thing first, we've got to establish that the landlord can charge a service charge, has a legal right to do so, before we can move on to how it actually handled the other aspects we can look at, such as communication, transparency, as I previously listed. So in this case, the first major concern was that whilst the tenancy agreement, which would be a legal basis for a landlord charging a service charge, whilst it did contain a provision to be able to charge for services provided, it referred to a schedule of services which didn't actually exist. So the problem with that was, at the time of sign up, the tenant didn't know which service charges she was agreeing to pay, or their initial amount, or mechanism for them increasing or decreasing as the case may be. That's important because, as I said at the start, this is a fixed service charge. So what that means is the amount is set out each year to be paid and isn't subject to revision. Whereas if you have a variable service charge, an estimate is given at the beginning of the year, but then at the end of the year, once all the accounts are finalised, there could be a credit or debit based on that. So it's important that landlords get it right, that there is a provision for the service charge and the resident is very clear what they need to pay, so that they can charge that service charge. So in this case, the concern was that the resident didn't have that information when she signed the tenancy agreement, nor was she provided with that information at any point during her complaint. A major part of the complaint being, of course, that she didn't know what she was paying for. She knew the sum total, but not what it was made up of. Therefore, she couldn't determine whether those services being charged for were being provided or not, and whether she was being charged what she should have been being charged for or not. So it all became very, very complicated for the resident in trying to work that out. So in terms of maladministration, we found that the land hadn't clearly demonstrated its legal basis for charging a service charge. And we also found under our scheme that it wasn't fair in all the circumstances for the landlord to have been charging the service charge. We found that the information provided and the responses to the resident were poor, in that there were delays between questions being asked and responses being provided, and then the responses were either lacking information or completely ignored certain questions from the resident. The landlord hadn't followed its service charge policy. Its policy was very good, and it set out all the things I've just described about being transparent and clear and giving good detailed advice and communications. But unfortunately, in this case, the landlord hadn't done any of that, and so it hadn't followed its policy. There was another complication with this matter. As I said at the start, that the resident is disabled. The resident's a wheelchair user, and she had an adapted property to enable her to fully access it. And that meant that the property was larger than another comparable flat of the same number of bedrooms. The landlord's practice in terms of apportioning service charge, so dividing it out, was to do it based on square meterage of the surface size of the property, not the number of bedrooms as would conventionally be done, or an equal division between the number of properties within a block or an estate, for example. So in effect, the resident was being charged more by virtue of having a larger property, even though she had that larger property, because of her disability. So in terms of the investigation outcomes, we found that the landlord hadn't had due regard, that is, proper consideration of its duties under the Equality Act 2010, not to indirectly discriminate against someone due to a criteria provision or practice. In this case, the criteria or practice will be the way it apportions service charges. Now, it's very important to point out that as we're not a court, we can't make a legal determination or finding to say that the Equality Act had been breached, because that's beyond our jurisdiction. But we could certainly find that the landlord hadn't demonstrated that it had proper consideration or due regard to its obligations in the way it charged the service in the first place, and the way it handled the considerations when raised by the resident within the complaint. So that was another area of complexity which went all together to be the basis of the maladministration finding.
Thank you, Stephen. So yeah, we found quite a few serious issues there, not with just with how the landlord managed its service charges, but that lack of clear information and the way that the resident was treated as well. So what actions did the landlord take to put things right after our findings?
So before we actually issued our report, positively, the landlord did review its service charges, as in fairness it had said it would do to the resident all along, although it had taken some time to do it, and worked out that the figures it had based it on from the managing agent weren't correct, and so it recalculated the charges, and it did refund nearly £4,000 to the resident's service charge account, which was positive. It also said that it would charge less based on the square meterage apportionment issue, because the property was an adapted property, although it phrased it as a discount, which perhaps wasn't the best language to show, again, due regard to the Equality Act, but nevertheless it did make that change. Following the determinations and the report being issued, the landlord did comply with the Ombudsman's orders. It provided an apology for its failings, and it also paid the £1,000 compensation that we ordered it to pay. It also, as per our order, took legal advice on its position regarding charging a service charge from the solicitors, and reviewed its position as per the order. Concerningly, it came back on the basis of its legal advice that it believed it was entitled to charge the service charge. Now, legal advice is privileged, which means it does not need to be shared outside of the solicitor-client relationship, so we couldn't compel the landlord to provide that legal advice to us, which is quite correct. But still, we were concerned that it had come to this conclusion, and we did write to the landlord to show our concern, even though, as I said right at the start, we're not a court and we can't make that legal determination. We can point out the potential issues with the way it was handling the service charges, in the hope that it would perhaps look again in the future.
Thank you. It's positive to hear about those steps that the landlord took to address the situation, you know, like recalculating the charges and issuing the refund and following our recommendations. But it does sound like there are still some areas that could be improved as well. So that leads me actually to my last question for you, Stephen. What lessons can other landlords take from this case when it comes to handling complex service charge complaints and supporting residents with additional needs?
So that's a really good question, and really is something that I'd like to highlight through this podcast to other landlords. The complexity of the nature of service charges, and the good practice that really can be taken forward by all landlords is to be clear and transparent about charges. If the landlord has a legal basis to charge a service charge and provide a service, then that's perfectly good and proper. But it needs to be really clear with the resident at the point the resident signs the tenancy agreement, signs up initially, and then throughout, which services are being provided, what the charges are for them, and how they're being calculated and apportioned or shared out, so that residents are always clear on what their liabilities to pay are, and also can hold the landlord to account in terms of services that need to be provided, so that everyone is on a level playing field in terms of obligations, rights, and responsibilities. The best way to do that is to provide easy to understand information. Not many of us are accountants, I certainly am not, and most residents probably aren't either. So highly complex invoices and schedules and spreadsheets are not the best way. If the landlord can provide a simple breakdown that shows the itemised services and the amount charged per week or month or year, similar to a basic bank statement in style, then residents are going to be able to understand that, and if there are any queries, they'll be able to raise them clearly, and everyone sort of knows what's going on. Equally important is to respond quickly to queries. As in life with everything, nobody likes waiting a long time if they are concerned that something isn't quite right or they want to check their understanding. If landlords can provide that reassurance or that information, or if need be that correction quickly, then that should hopefully resolve most of the need to make a complaint at all. And really that's ultimately the end goal, is to reduce the number of complaints through providing the services and facilitating them correctly in the first place. Equally important is to admit when things have gone wrong. Sometimes things happen, everyone's human, or you can have system errors, or you can have incorrect information or updated information. Again, perfectly normal in life, but the important thing is to say, we've got something wrong. Yes, we got this wrong. This is how we're going to fix it. And again, if that can be done in a quick way and a fair and clear and transparent way, then again, that should avoid the need for complaints and for escalations, and generally have more happy and satisfied residents. The important thing to remember, I think, is that the landlord is in a position of power, being the landlord. It also, depending on the size of the landlord, may have massive resources and knowledgeable experts in all types of fields. The resident doesn't have any of that. Residents aren't expected to be experts in service charges, and they don't have massive resources to investigate and challenge. So really the emphasis should be on the landlord to be providing a fair service that's correct, clear, transparent and responsive, so that everyone's on a level playing field and knows what's happening. And if that can be achieved, then there should be the less complaints coming through.
Fantastic. Thank you very much, Stephen. So the key lessons I've sort of really taken there are really all around clarity, that was responsiveness and accountability, and you made such a good point about doing that early on. So right from the start and going forward as well, and about landlords being transparent about those charges. And I think providing information that's easy to understand is so important, because having the information there, but if you can't understand it, it's no good, does it? So yeah, I think as well, your point about owning up to mistakes and putting things right is really important. It's such a big part of making sure that residents, especially residents with additional needs too, are supported appropriately. So just thank you, Stephen, a huge thank you for taking the time to talk through the case with us. It's been really interesting to hear all of your insights, and I'm sure it will give landlords plenty to think about when it comes to improving their own practices and service charges. And I hope we can have you back again for another episode soon. So, and thank you to everyone for listening, and see you next time.